Hello and welcome to this edition. In this edition, we will understand the judgment of Honorable Karnataka High Court in the case of Srimati Preeti versus Income Tax Officer. The citation of this case is 170taxman.com 673. Right? Now, this case is all about the assessment proceedings against a deceased person. Honorable High Court has examined the validity of the notice issued under Section 148 against a deceased person, and also the Honorable High Court has examined whether proceedings can be initiated and continued against the legal representative, for which a reference is made to Section 159 of the Income Tax Act. The assessment is for assessment year 2016 and 17. 2016-17 is the assessment year in question. Now, what has happened is the SSC has passed away on 14th of October 2022. These dates are very, very important. Now, the notice under section 148 is issued on 13th of March 2023, and the assessment year in question is assessment year 2016-17. Now, against this assessment, the legal representative of the SSC contended that the notice itself is valid and the subsequent assessment order, penalty orders, etc., are liable to be quashed. That is the contention of the legal representative of the SSC. Now, what the revenue has sought is it wanted to continue the proceedings against the legal representative. This is the revenue side. Now, what are all the legal provisions which are involved in this particular issue? That is Section 148, means income escaping assessment under Section 147. Notice has been issued under Section 148 of the Income Tax Act. Next comes the Section 159, wherein the provisions relating to assessment of a legal representative is concerned. And also Section 149 deals with the time limit within which a notice under Section 148 can be issued. Right? So these are all the sections, Section 148, 149, and Section 159. Now, the questions before the Honorable High Court is whether a notice under Section 148 can be issued against a deceased person and whether the proceedings are valid. Honorable High Court has held that no, means a proceedings or an assessment order can't be passed against the deceased person, or a notice, to be more specific, a notice under Section 148 cannot be issued against a dead person. The next question that is before the Honorable High Court is with regard to, can proceedings be initiated against the legal representative under Section 159? Yes, proceedings can be issued against the legal representative or proceedings can be continued against the legal representative, but it should comply with Section 159 of the Income Tax Act. Next, what are all the court findings in this particular case? Honorable High Court has held that notice against a deceased person is invalid. So you can't issue a notice against a deceased person. And also, it was held that proceedings for 2016-17 cannot be initiated after 31/3/2023. This is because by virtue of Section 149, because the time limit for issue of the notice is given in Section 149 of the Income Tax Act for assessment under or issue of notice under Section 148. Now, previously, we examined the dates. What has happened? The SSC has passed away on 14/10/2022. The notice is issued on 13th of March 2023. This is in complaint of section 149, because for section 149 for assessment year 16/17, the last date to issue notice is 31/3/2023. But what happened? Though section 149 time limit is complied with, the notice is against a deceased person, because the deceased person already passed away in the month of October 2022. Now the question is whether the proceedings can be initiated against the legal representative. Yes, as per section 159, the proceedings can be initiated against the legal representative. But there is a catch here. The notice should have been issued within the time limit, that is 31/3/2023. In the current case, what has happened is notice is issued within the time limit under section 149 against a dead person. By that reason, it became invalid. Whether proceedings can be initiated against a legal representative, yes, section 159 provides that. But what has happened is the proceedings against the legal representatives were not initiated within the time limit specified under section 149. That is within 31/3/2023 for assessment year 16/17. Now, what is the outcome of this judgment? The notice under section 148, as well as the order passed under that section, as well as the penalty orders, are quashed. Why the orders were quashed? Because the proceedings against a deceased person are null and void, and proceedings can be initiated against the legal representative, but the time limit has expired as specified under section 149 of the Income Tax Act. Now, what are the key takeaways that we derive from this judgment? Notice against a deceased person is invalid and it is unenforceable. Also, proceedings against the legal representative can be only in accordance with section 159 subsection 2, and also section 149 is to be complied with. Now a question arises whether there is an obligation for the legal representative to inform about the death of the SSC. Honorable Court has held that there is no such provision in the law which will force the legal representative to inform about the death of the SSC. And finally, the single judge's order has been upheld by the Honorable Karnataka High Court, and also that the catch point here is for the proceedings to be valid under the law, time limits are required to be adhered to. And also, there is a protection under the law to the legal representatives against invalid proceedings. Thanks for watching. See you next time.